everybody, how are you doing? So we're back with a legal stream of lawyers and liquor edition of Boozy's Legal Funhouse here on June the 15th, 2020 at 7 p.m. Eastern Time. And a lot has happened. A lot has happened. And that's what we're going to focus on. Like if you've tuned into the legal streams before, a lot of them have been like me going over like legal news and things like that, and then like one topic and everything. Tonight we got one topic, and we got one topic only. Thank you, Quaxo Method, for subscribing for your 22nd month in a row. And we're gonna jump right into that topic because man, we have a lot to cover. Tonight's topic is very simply, very clearly, the law says trans rights. The law says trans rights. And in saying that, the law has said it through Bostock v. Clayton, a Supreme Court decision that came down today. This was argued back in October of 2019, and it's actually consolidating three separate cases into one opinion. Those cases being the titular Bostock v. Clayton County, where a gentleman who worked for the county and did a wonderful job, joined a gay softball league, and upon it being discovered, he was a member of a gay softball league. I've really got to wait. Upon it being discovered he was a member of a gay softball league, was terminated from his employment, so he brought an action under Title VII of the Civil Rights Act. Title VII being the section of the Civil Rights Act that prevents employment discrimination on the basis of age, race, sex, national origin, religion, all those great things, what we call in the law to be protected classes. In addition to his action, there was the action of, I actually have to scroll down to find the case names, because I don't have all the case names in my head. Altitude Express, Inc. versus Melissa Zarda and William Allen Moore on behalf of the estate of Donald Zarda. Donald Zarda was a skydiving instructor who had a wonderful work history, but when doing a tandem skydive with someone, made a joke along the lines of, to the young female woman, "Don't worry, I'm gay." And that was reported back to his employer, who then terminated him. He regretfully died. His family continued the action that he filed under Title VII. And finally, RG and GR Harris Funeral Homes, Inc. versus the EEOC, the Equal Employment Opportunity Commission. That was a case where a funeral home director had transitioned from male to female, went back into their job, and said to their employer, "Hey, just to let you know, I am now Amy Stevens, and moving forward, I'm going to come to work in appropriate clothing and dressed appropriately for a person of the female gender, because I am a person of the female gender." Their employer then fired them and said, "No, we're not going to let you do that." All three of these went up to the Supreme Court on the basis of Title VII claims. Now, Title VII claims are, as I said a moment ago, claims against discrimination in employment on the basis of national origin, ethnicity of race, religion, on the basis of sex, all of those coming in. And over the years, it has been a very narrowly interpreted sort of thing by a lot of courts. In fact, up until 2017, no matter how many LGBTQIA plus cases had been brought, they were always basically being stopped off with people saying, well, it doesn't protect that. Now, back in 2017, though, circuit courts, federal appellate circuit courts, started ruling differently. They started saying, of course it protects that. It protects it because it protects from an adverse employment action. We'll get into that in a minute on what that means, on the basis of sex. And therefore, discrimination based on these things, based on LGBTQIA+, is discrimination on the basis of sex. This was a circumstance of a circuit split. Okay, circuit split is where one federal court holds one way, another federal court holds another way. In this case, it was the 11th Circuit and the 6th Circuit of the United States, which said, of course, it's discrimination because it is founded in sex. And the 2nd Circuit came back, which would be the whole New Yorkular region, came back and said, no, it's not discrimination because it does not specifically protect gender orientation or gender identity or sexual orientation. When I say it, I'm talking specifically about Title VII of the Civil Rights Act, which was put into place in 1964. I'm going to cut to the end. I'm going to make it easy because you already know this part. The Supreme Court of the United States, today in a 6-3 opinion, has stated that an adverse employment action taken against a person who is LGBTQIA+, and we're going to keep using that acronym. Somebody recently said, oh, we're using the ever-expanding... Fuck you. We're going to keep using the acronym. It's a big tent, motherfucker. We all get to come under it. Calm down. All right? LGBTQIA+ falls under the protection of Title VII of the Civil Rights Act. And you cannot terminate someone on that basis. I have been watching Twitter today as I read the opinions, as I took my notes. I have seen some of the questions that have popped up. I've seen some of the statements that have popped up, and I will be addressing some of them tonight. However, before we begin, I have to do a regular disclaimer. All right? I am an attorney, but unless you have come into my office, paid me a fee of my choosing, entered into an engagement relationship with me, I am not your attorney. All right? What we are talking about tonight is the educational aspect and the hopefully entertainment aspect of this ruling, and explain a little bit around the law. Okay? Till Wolfie says, I love It's a Big Tent, everybody can come along. I stole that, believe it or not, from the GOP. The grand old party. It's a big tent. Everyone's welcome. So let's go ahead and hit some of the high notes of the opinion today. All right. First, I gotta point out who wrote the opinion. The majority opinion of the court, was written by Neil Gorsuch, which was a mind blower for most lawyers out there. Gorsuch is a conservative judge. Gorsuch came in and was appointed by Trump. He was the appointment by Trump that stole the seat. Actually, it was Trump's first Supreme Court appointment, and was considered to be kind of like, everybody's looking at him going, ooh, because he was almost like Scalia-light to an extent. That's kind of how he's being viewed. We thought he was going to be a very textualist justice, and it turns out he is, just not in the way that they want him to be, because Gorsuch did go textualism. He actually applied it in here in delivering this opinion, which was surprising. Now, your dissenting justices are going to be set forth right over here. Gorsuch delivered the opinion. He was joined by Roberts, Ginsburg, no surprise, Breyer, Sotomayor, Kagan. Alito dissented, Thomas dissented, Kavanaugh dissented. Thomas joined in Alito's dissent. Kavanaugh wrote independently. We're going to cover Alito's dissent a little bit. But let's go over some of the high points. The very first high points that you have to understand. First, what is textualism? Textualism is looking at the law as it is written and deriving the intent of the law from that with no real extrajudicial factors. It has been a mainstay of conservative judges for a long time in doing what they call stopping the legislation from the bench, the interpretation of a law to mean something that it is not written to say. So for this to come from a textualist is kind of fun. When I say kind of fun, I mean it's fucking mind-blowing. But yeah, they start off strong, though. Let's just read right off the bat. One thing that I want to read. In Title VII, Congress outlawed discrimination in the workplace on the basis of race, color, religion, sex, or national origin. Today, we must decide whether an employer can fire someone simply for being homosexual or transgender. The answer is clear. An employer who fires an individual for being homosexual or transgender fires that person for traits or actions it would not have questioned in members of the different sex. I want to stop and point out just a couple things. The very first thing is, as we talk tonight, we are going to be using phrases as we discuss the opinions such as homosexual or transgender, or gender identity, or sexual orientation. We are using those because those are the terms that SCOTUS refers to. We will be using phrases such as gender assigned at birth or sex assigned at birth. We will be using those phrases. Keep in mind, this is a very high-level bomb site overview of the decision, so please don't jump on me too much when we do that. Those of you who know me know that I do take it upon myself to make sure to educate myself on it, but when I say homosexual, look, I know it's gay. I know it's LGBTQIA+. I know. But we're referencing the opinion. So we're going to reference the opinion for this. The decision in this matter, and we're going to start off right off the bat talking about, is fun in a way that I did not expect it to be fun. The very first thing that Gorsuch comes out of the gate and says is more or less the common denominator in every single one of these decisions is sex. And when we are using sex in this context, what we are talking about is sex assigned at birth. All right. When you come out, do you have a penis or a vagina, and what they write on your birth certificate? That's what we're getting at when the court's making the determination. And what the court has basically said is that's where your determination starts. That's where it holds off. And the fact that you may apply a policy equally to male and female is not a defense if the policy itself is discriminatory in application. The classic example here would be saying that a policy is not discriminatory because it doesn't only apply to people who are assigned male at birth, but applies equally to people who are assigned male at birth and are assigned female at birth. I know male and female, just bear with me. And what does that mean? All right, that means that if Tom wants to go into work wearing a dress, because Tom likes wearing dresses, and he is fired for that, they cannot say, well, we would have fired Janet for coming in wearing a men's suit. All right. And the reason they can't is because the protections under Title VII, as Gorsuch states very clearly, are not protections to a group. They are protections to the individual. All right. So if Tom goes in wearing a dress and Tom is fired for wearing a dress, it's not a defense to say, yeah, but we would have fired Janet for doing it as well.
Just the tip. The tip.
Thank you very much. That's not how it works, because the discrimination is against Tom. All right? So the discrimination against Tom is what is in play here. And to point out how old that argument is, it doesn't count as discrimination because we're not discriminating against just that group. That's actually the same argument that was used in a very famous case called Loving v. Virginia. Now, Loving v. Virginia, if you're not familiar with it, was the case where the Supreme Court struck down legal bans on interracial marriage. And Virginia, the Commonwealth of Virginia, had defended a ban on interracial marriage by saying it doesn't discriminate based on race. The law applies equally. A white man can't marry a black woman exactly the same as a black man can't marry a white woman. It doesn't just prevent African Americans from marrying people of different races. It prevents everybody. We are all equal in being discriminated against. Therefore, there is no discrimination. And the Supreme Court said very succinctly in that case, get the fuck out of here with that. So when we come in on this, that if it applies equally to people of all sexes, it can't be discriminatory on the basis of sex, is right out the fucking window. That's gone very quickly because it's an individual right. Now, how did we reach that? How do you reach this decision? I actually have to search through my own documents now. We got to go to the but-for causation. Yes, we all know the joke. What's a but-for pooping? It's for pooping. It's for sitting on. It's for anal sex if you want to keep your job. Now your butt is for anal sex and employment, and you're fine. No one can take that away from you. Likely. We'll cover it. I promise you. But the point of the matter is but-for causation. What is but-for causation? Gorsuch goes through what but-for causation is. Okay? But-for causation is if you look at what happened in a situation. All right? It is because of. The act is because of something. In this case, it would be the discriminatory act took place because of the status of the person. And how do you determine that? Well, you look at the situations. Now, just to point out, very quickly, Gorsuch goes through this whole thing on but-for causation, how but-for causation works. I'm going to say but-for as much as I possibly can because I like saying but-for. But-for causation. If X, then Y. And if not X, then not Y. That's the way to break it down into algebraic terms. Now, forgive me if the algebra is wrong. I became a lawyer because I don't like doing math. Didn't work out well for me, by the way. So in a but-for causation case, as Gorsuch gives you, he gives you the classic example of but-for causation. All right, there is a car accident. All right, somebody blows through a red light. All right, if they had not blown through that red light, the accident would not have happened. Therefore, blowing through that red light is the but-for cause of the accident. All right, and something can have more than one but-for cause. All right, if somebody blew through a red light while taking an illegal left-hand turn and caused a head-on collision, there are two potential but-for causes there, aren't there? There's blowing through the red light, and there's taking the illegal left-hand turn. Both independently could cause that. All right. Which one was the primary cause is a different question. But either of them, looked at independently, could have caused, so both are but-for causes. In this case, as Gorsuch runs it down, the way you determine a but-for cause is pretty simple. You look at the circumstances, you look at the facts, you look at the result. And then you change something. You change something to see if the outcome changes. All right? If there is a thing different between the cause and the outcome, then it's not a but-for cause. If Bob stops on the red light and the accident doesn't happen, that's an indication that blowing through the red light is the but-for cause. If Bob stops on the red light and the accident still happens, that is an indication that blowing through the red light is not the but-for cause. So we look at them kind of in isolation, each factor in isolation, and we see if changing that factor, that one factor, changes how things go moving forward. I don't know which one of my children is trying to sneak in the room, but they've all been told not to. So let's look at it kind of in this situation. All right. Tom is gay, and he is late to work. On the same day that his employer discovers he's gay, he's late to work. Tom is then fired. Matthew is straight, and he is late to work. Matthew is not fired. In that circumstance, when we change that one factor, Tom is gay, the indication goes strongly towards being gay is the but-for cause of termination. And we know this because when we looked at Matthew's factor, we changed Matthew's case to Matthew not being gay. Matthew is not terminated. All right? So let's say Tom is gay and Tom is late to work and Tom is fired. Matthew is straight and Matthew is late to work and Matthew is fired. In that circumstance, we'd say, well, it's very unlikely. Excuse me one moment. No.
Come on, buddy. Come on. You can show Daddy your truck later.
In that situation, it is unlikely that being gay is the but-for cause. Both of them were late to work. Both of them were fired. Changing that one factor does not create the cause. And that one, it would be being late to work is that cause. Now, when we look at it after the fact, it can be kind of hard to determine that. Because you have to determine what's the factor. What are we changing? And in Gorsuch's opinion, very, very quickly to lay it out, Gorsuch says, well, what we're changing is the sex of the person. All right? Matthew is a male who sleeps with men. Matthew is fired. Susan is a female who sleeps with men. Susan is not fired. If Matthew was a female who sleeps with men, would Matthew have been fired? And if the answer is yes, under Gorsuch's determination, that is the but-for cause. It is, who are you? All right, what is your sex assigned at birth? To put it in this way, two employees, same work history, all things equal. One of them is transgender. That one is fired. Okay, that's where we're looking at it. That's the determination. And the way Gorsuch gets there is actually pretty interesting. And we'll get into that in just a second. But the way he gets there is actually pretty interesting. Now, one thing that Gorsuch does mention here is that the but-for cause is not actually the strictest standard that could be used. There is another standard put forth in the 1991 proposed amendments to the Civil Rights Act that creates a motivating factor test, which means it doesn't have to be a but-for test. It doesn't mean if you take away this one thing, that wouldn't have happened. But rather, if this one thing at all fed into the decision, it wouldn't have happened. Or it would have happened. Somebody asked if my camera froze up. Not on my end. So, where do we go from here? What's the next part? And it's actually, applying but-for is actually a bit of a more stringent test than the motivating factor test. Things that we do have to remember real quick before we go any further. When I say but-for, I'm not saying it is the cause somebody was fired, because the law doesn't require that. Gorsuch actually goes into length in his opinion to make it very, very clear that the law does not say it has to be the primary cause of an adverse employment action, but rather that it need only be a cause of an adverse employment action. So, it doesn't have to be you were fired for being gay. It just has to be a part of why you were fired. So, if your reasoning is he was fired because he was late, okay. He was fired because he was late and he didn't bathe and it turned off customers. Okay. He was fired because he was late, he bathed and he turned off customers, and he was gay. That's the hard stop. All right? Doesn't matter if you have the other three factors sitting right there saying these are all the reasons he was fired. You can't have that one. Basing an adverse employment decision off of the status of a person in a protected class is a Title VII violation in and of itself. The other factors that come in don't matter. It doesn't have to, and Gorsuch goes to lengths to point out, it doesn't have to, the way the law was written, be the primary cause. It doesn't have to be the reason you were fired. It just has to be a reason you were fired. That sounds like that's a pretty reasonable thing. And people will say, how does that work, though? How did we reach this determination, and why wasn't it reached sooner? And the answer is strange. And I say the answer is strange because it all relies on the concept of sex as being assigned at birth, of your biological sex as you are assigned at birth, driving the decision. And that seems counterintuitive. I'm not a doctor, and I'm not going to pretend that I have a wide breadth of knowledge on sex versus gender and gender identity and all that. I don't. Okay. However, if someone says, I was assigned male at birth, AMAB, but I am a woman, and they live their lives as a woman, and they are fired for that. The way the court's getting there is saying, this is not you are firing them because they're a woman. This is you are firing them because they were assigned male at birth, and you have an expectation of how that should happen and how they should present themselves. And they are not conforming to the expectation. Therefore, your firing of them is a decision made based on their sex. All right? So Gorsuch is saying, more or less, sex is immutable. It is what you are assigned at birth. And then he is saying, because sex is immutable, you cannot look at these other traits and say they are not conforming, fire them for that, and then say, but it's not really because of their sex. I'm not firing them because they're a man or a woman. I'm firing them because they're a trans man or a trans woman, or they're gay or they're lesbian. My decision isn't based on their sex. It's based on who they sleep with or what their gender is. And Gorsuch and the majority of the court is saying, no, that's still a determination made based on sex. Because you are expecting them to conform to certain societal norms. And when they fail to conform to those norms, you are making a determination based on sex. Now, there were interesting arguments made about this in front of the court. The arguments, the larger arguments against it, fell into a couple camps. The first camp that they fell into was more or less nobody refers to it as sex discrimination. Nobody calls it that. Let's see if I can find that in here. But basically, I mean, that was the first. There we go. People don't call it sex discrimination. That was a real argument. I just want to be clear. That was a real argument on behalf of the employers against finding the way that the court found today. It can't be sex discrimination because nobody calls it sex discrimination. They don't say this is sexist. They say this is homophobic. This is transphobic. And that was fun because Gorsuch goes straight down through and essentially says, and I shit you not, it doesn't matter what you fucking call it. All right? It's I have referred to it here as my John Adams argument. Because Gorsuch's response to nobody calls it sex discrimination. Nobody calls firing your gay employee or your transgender employee or your lesbian employee sex discrimination. That's not the common parlance, so it can't be what that means, is what I like to call the John Adams response. It's a great response. John Adams said, "Facts are stubborn things. And whatever our wishes, our inclinations, are the dictates of our passions, they cannot alter the state of facts and evidence." As the employers in this made multiple arguments that it can't be a Title VII protected class, that LGBTQIA+ cannot fall under that, because no one refers to it as sex discrimination. Gorsuch says it doesn't matter what you call it. Because the fact is, if Bob is a model employee, and you love Bob to death, and then Bob brings his husband to the company picnic, and suddenly on Monday Bob's not employed. But if Susan were to bring her husband to the company picnic, Susan would still be employed. But if Susan were to bring her wife to the company picnic, Susan would be fired and Bob would be employed by bringing his wife. Then the fact is you are making a discrimination based on sex. If you change one immutable fact, being the sex of the person, leaving everything else alone, leaving the rest of the qualifying statement, if you focus on that one thing, a man who is married to a man, a woman who is married to a man who lives as a man who lives as a woman who lives as a man, a woman who lives as a woman. If you change that very first mention of sex, and the outcome changes, it doesn't matter what you call it. It is sex-based discrimination. And that's kind of fun. It's kind of fun because Gorsuch is saying, of course, it implicates sex as assigned at birth. Because sex as assigned at birth, as anybody's going to tell you, creates a large number of social expectations, of societal norms, of things people can and can't do without being judged. So, of course, that determination, men should marry women, is going to affect it. Because if Bob is a man and Bob marries a man, Bob is acting outside the norm. And if Bob is fired for that, then that is discrimination based on Bob's sex and the societal expectations that are placed upon him. And Gorsuch really, he sums that up very well in all of this. He goes through it. And, you know, it's funny how he does it. Because he even says, it doesn't matter what an employer calls it. It doesn't matter. Because at the end of the day, that's what it is. He actually asked it, doesn't the resulting applications disclose which individuals are homosexual or transgender without revealing whether they also happen to be men or women? So if you put a checkbox on an application, this is actually a fun little thing. Put a checkbox on an application. Are you gay or trans? Are you a member of the LGBTQIA+? And somebody checks it and they go, yeah, we don't want no gay people here. So you're not hired. Well, doesn't the fact that they're blanket not hiring all gay people mean they're not discriminating against sex because they're not choosing gay men versus gay women? No, it doesn't. And Gorsuch says, because you're still making a decision based on the sex. You're still making that determination. Likewise, there was an argument made at some point during the oral arguments here that it's no different than a 1950s housewife applying to be a mechanic and being turned down because she was a woman. And the dissent kind of snipes at that a little, and Gorsuch snipes back. Because they kind of are arguing that, well, really, to be fair, what we should say is, would it be different if a 1950s housewife was applying to be a secretary and she wasn't hired because she was a woman? Because that would have been more societally appropriate. And Gorsuch's response is, no, it wouldn't be. You're changing two things. You're not changing one thing. You're completely changing the hypothetical. Which, by the way, is something in law school they tell you about. You can't change the hypothetical so much that the hypothetical doesn't apply. If your hypothetical is, well, it's the same thing as a woman applying to be a mechanic in the 1950s, yeah, that's still discrimination based on sex. If you then say, well, it's the same thing as a woman applying to be a mechanic in the 1950s, but really by mechanic we mean secretary. That's not the same hypothesis. You're just going to change one fucking factor, not the whole goddamn thing. All right? And Gorsuch kind of goes on to that. Now, we come down to something that's actually even more interesting, which is the concept of Gorsuch as a textualist. And make no mistake here, Gorsuch is a textualist. All right? And that means he attempts to read the law as it is written. All right? Now, the law as it is written just says sex. And the idea behind that is the opposing parties were arguing sex as it was understood in the 1960s did not include LGBTQIA plus rights, and therefore should not be understood now to do that. And that's a huge thing in conservative drafting, which I'll get into in a moment as we talk about Alito's opinion, his dissent. That is, you can't interpret into the law what was never intended there. And Gorsuch comes back and says, where there's an ambiguity, which is correct, it's law construction, where there's an ambiguity in the meaning of the law, then certainly we look to what was intended. But here, there is no ambiguity. The response of Gorsuch to that is the definition of vehicle in a Vehicle Theft Act. A vehicle at the time of writing may not have included many things. It may not have included airplanes or things along those lines. All right. Now, Gorsuch actually kind of claims the opposite. What he says is the National Motor Vehicle Theft Act in 1931 arguably could have included airplanes. However, from the context surrounding it, we get to look at it and say, that's obviously not what it meant. It obviously didn't mean airplanes because they moved on land as well. But a vehicle as defined in maybe the 1800s would not have included cars. So, but we can know from the context, from the purpose and the surrounding circumstances, that when we are updating the definition, we have to include cars. We have to understand those things. We have to say, yeah, obviously, it means cars too. All right? Whereas the people arguing against it would say, well, no, if it means cars, it would say cars. If vehicle meant car, it would say car. If vehicle excluded airplane, it would say except airplanes. And because we have that, because that language is not in there, you cannot read that language into it from the context and the surrounding circumstances. You must defer to Congress and give them the opportunity to add or revise that language first, which is sort of asinine because you can look at it. And by the way, gay-mobile. That's what I was thinking of. I was thinking of gay-mobile. Just bus filled with gay men. Just the gay-mobile. Anyways, and you know, it's a fun opinion though, because it kind of goes back in and says that. It says, no, we're not going to do that. We're not going to narrowly construe this. Additionally, he kind of points out that it's not proper to look to legislative history or things that took place after that to determine what was or was not included, where there is no ambiguity. In Gorsuch's view, there is no ambiguity in the word sex. It means any determination in employment that is made on the basis of somebody's sex as it is assigned at birth, and their compliance or non-compliance with the societal norms inherent therein. And if it is a factor, not even the primary factor, but a factor, then Title VII forbids discrimination based on those grounds. And to go back and demand that we look at the legislative history or demand that we apply what could be a more favorable reading of commonly understood terms, or really to suppose, in the absence of clear indication otherwise, what was meant in the minds of the drafters and what they meant to include or exclude when they were drafting and approving laws is dangerous. And he phrases the danger pretty well, stating, I have it written here, a low-key call-out of the demand for a narrow application of a broad law. And he has a wonderful line here. Often lurking just behind such demands resides a cynicism that Congress could not possibly have meant to protect a disfavored group. To refuse enforcement because the parties before us happened to be unpopular at the time of the law's passage would tilt the scales of justice in favor of the strong or popular and neglect the promise that all persons are entitled to the benefits of the law's term. Did Neil Gorsuch just call them out? Did Neil Gorsuch just call them the fuck out? Because that's what he did. Every argument that was raised against LGBTQIA plus protections falling under the sex discrimination prong of Title VII was, you cannot interpret this law so broadly as to include those people over there. And Gorsuch said, yeah, I get it. That's what you want us to do. But that's been a really good way to deprive people of their rights. He actually goes into an example here of a law regarding public entities being unable to discriminate against any qualified individual with a disability, and how when that law for the ADA was applied to the post office, nobody said anything. Everybody was fine with it. But the moment courts started applying it to prisoners in Pennsylvania state prisons, everybody lost their damn mind and said the law as it was written was never intended to apply to those damn dirty people. And Gorsuch is saying, yeah, it's been a really good argument to deprive people of rights and deprive people from the protection of law, and we're going to reject it now. We're going to say no. They wrote sex. The thing you're discriminating on them for is intrinsically and immutably linked to their sex, at least as assigned at birth, and your perceptions of what is and is not appropriate based on that. So when you make that decision, you're violating the law. His slamming at home are two things I love. Ours is a society of written laws. Judges are not free to overlook plain statutory commands on the strength of nothing more than suppositions about intentions or guesswork about expectations. We do not hesitate to recognize today that a necessary consequence of that legislative choice, an employer who fires an individual merely for being gay or transgender, defies the law. Holy shit. I want to get into the dissent. And I'm going to get into the dissent, but before I do, I want to cover a couple small things. I mean, not really small things, but things you need to know. And the very first thing is that this is not a countrywide proclamation. It is in that it is now binding precedent in all federal courts and in all courts that apply Title VII of the Civil Rights Act. This is binding precedent now. However, the act itself, the Title VII Act, is limited. Okay. First, the largest limitation is what Title VII actually applies to. All right. Title VII will apply to the failure to hire somebody or the refusal to hire somebody based on sex and any protected class, but for these purposes, sex. It will apply to the decision to fire somebody based on that, even in part the but for, like we discussed earlier, or any discriminatory action. Right? Now, what isn't a discriminatory action? We call them adverse employment decisions. Okay, it's not just hiring. It's not just firing. It can be a refusal to promote somebody, or demoting somebody, or significantly changing their job duties to one with less responsibility, even without a lower in pay. It can be cutting hours or lowering hours. Anything that negatively impacts your job can be an adverse employment decision. Okay. And generally, in those claims, disciplinary action as well, generally in those claims, what you have to show, because it is an individual claim, is disparate treatment. Disparate treatment is where it is an intentional treating of someone differently than others who would be similarly situated based on sex, where they would tolerate that thing if sex was not the factor. So that would be the situation like we're talking about earlier. Let's say Susan comes to the office with her husband, and Bob comes to the office with his husband. They are both equally situated, equally good employees. However, Susan gets the promotion, and a but-for factor in making that determination that Susan would get the promotion over Bob is that Bob has a husband and is not a woman. Okay? That would be your but-for factor of an intentional act based on sex. Once again, it is determined based on an individual, not a group. That means the classic example would be if somebody were to sexually harass their employee, their specific employee, say Molestco sexually harasses Susan, but Molestco shows preference in hiring two women. The fact that Molestco treats women well as a group does not overcome the fact that Molestco individually did violate Title VII as to Susan. Okay, so you have to remember, it's an individual right, not a group right. There is what we call the employee limit to Title VII. All right? Title VII on the federal level only applies where there are 15 or more employees. Okay, now how we get to that number is interesting. The definition of employee is where they've had 15 or more full, part, or temporary workers for a period of 20 weeks or more at any point in the year preceding the filing of the action. Okay, that's how we get to that number of 15 employees. So if they have 3 full-time employees and 10 10 part-time employees and 2 temp workers, not independent contractors, but temp workers for the 20-week period, about 5 or 6 months out of the year in which you file the action and the discrimination took place in, then they fall under Title VII. Right? There are some nuances regarding that rule. For instance, there is the Third Circuit case of Nesbitt v. Gears Unlimited back in 2003, where they said there are some circumstances where we get a commonly controlled entity, like a company with 3 subsidiaries, and we apply 2 or 3 factors and look at if between the 3 of them they have 15 employees, and are they all really one enterprise for the purposes of this determination. So you could have a situation where you have 8 employees at Company A, 8 employees at Company B, but they're both owned by Company C, and Company C really directs them, and they're working together towards a common goal, so for all intents and purposes, you're going to treat it like there's one company for the purposes of counting employees. However, and this is sort of important to know, and we're going to go over to this, is the idea of a jurisdictional bar. Now, I'm scrolling down right now through the Federal Rules of Civil Procedure. This is Rule 12B. Okay. The very first rule in 12B, 12B1, is lack of subject matter jurisdiction. 12B is a federal rule that says, hey, when somebody files a complaint, you have to bring a motion under this thing to dismiss it right off the bat without having to file an answer. One of the grounds that you can bring a motion on is subject matter jurisdiction. It matters so much because it is one of the ones that the court sua sponte, that is, without motion, can dismiss on its own. If at any time a court sitting over a matter determines it lacks the subject matter jurisdiction to hear the case, they are directed to dismiss that case. In a case called Arbo v. Y&H Corporation, the court said, okay, but that number count is not jurisdictional in nature. And this is that right now, written by our wonderful friend, Justice Ruth Bader Ginsburg. That is not a jurisdictional question. That is a merits-based question. The reason that is important in the case of Title VII is a merits-based question is raised under 12b-6. 12b-6 being a motion that says, hey, they haven't actually alleged the claim. They can't prove it.
Just the tip.
And if you don't
Just
raise
the
that,
tip.
you waive that. So, if they do not assert, hey, they did not allege we had 15 or more employees in their complaint, and therefore that we would be beholden to this act, you don't get to point out later and say, hey, we don't have 15 employees, and bam, get it. It's a fact-based determination at that point. The court's not going to dismiss for lack of subject matter jurisdiction, and you could have waived the argument, such as lack of personal jurisdiction. All right? So the law applies based on the merits, not as a question of jurisdiction. The second thing that people tend to forget, the federal law is a baseline. And this is going to be important for something else I'm going to discuss after we talk about the dissent. Federal law is a baseline. Okay? The order of laws is there's the Constitution, all right? There's the federal laws, the statutes, the codes. That's where we find the Civil Rights Act. Okay? There's regulations and rules, administrative regulations and rules on the federal level. All right? Executive orders and treaties are in there somewhere, but not higher than this. Then we jump down to the states. Okay, so the federal law is supreme. And in many cases, the federal law, as it applies to states, sets a baseline. That means the federal law gives you a certain amount of protection. that the states cannot go below. So a state can't say, well, I don't care what the Civil Rights Act is, you can fire them, they're queers. They can't do that because there's a baseline now. The baseline is you can't give less rights than we give. You can't tell somebody that the state is to say you have less in the way of rights than the federal government has decided they are entitled to the 5th and the 14th Amendments. They can give you more rights, certainly, though. That's where we got the cake shop case, for example. A lot of those cases, because, like I've said, this question of protection of sexual orientation or gender identity has not been settled in federal law at all up until now, were actually based on state laws that gave a higher level of protection. Okay, that did say you cannot discriminate on that basis. That's where we get those cases from. That's why they come up now. All right. What this says is, hey, guess what, fucko? You can't fire someone for being gay or trans nationwide. All right. We're going to get to at-will employment. Hold your horses. Because before we get to at-will employment, what I want to talk about is Alito's dissent. And I hesitate to show Alito's dissent. There's one part that I do want to bring up. But what I want to talk about with Alito's dissent is just how disingenuous it is. I really want to just kind of go into that. Alito, who was referred to as Sculito for a little bit because of his go-in with Scalia, is a very hardcore textualist, and he is angry. He cloaks his anger in the concept of being mad about what he sees as a perversion of textualism to justify this, saying that there is no way that these protections could be based on sex because those are two different things. Which, I mean, I guess good news. Justice Alito believes sex and gender are not inextricably linked. As long as it means he gets to keep denying rights to people. And Alito believes that a statute should only mean what it obviously meant at the time it was written, which I find strange, because Alito certainly concurred with District of Columbia versus Heller, the Second Amendment case that said the requirement of the Second Amendment that a militia be formed for the private right to keep and bear arms, and completely discounted the words militia and said, no, that whole militia thing, that militia thing, we're not going to worry about that. We are not going to worry about the requisite portion of the Second Amendment. We're going to say it's a prefatory clause, but does not expand or limit the scope of it, and that those are two separate portions. So, you know, that's a little strange that Alito was perfectly fine with reading a broad scope into it when it was the Second Amendment on that, and he was perfectly willing to ignore or render as unreasonable a stated intention in the Second Amendment itself at that point in time. Now, I'm not making a judgment on your Second Amendment rights. I'm just showing the mental gymnastics here of a gentleman who joined in a determination that willfully disregarded words. Under a legal statute of interpretation, that every word should be given meaning if possible in any legal document, that you should always import a meaning, that no word in law is chosen inartfully. To then argue that word had a specific meaning at that time now, when he was perfectly fine disposing of the concept of a militia being a condition of the Second Amendment back in 2007. It gets even more fun, though, When we go over to Gomez Perez v. Potter, because that's a bit more fun. Alito wrote this opinion. This is an Alito opinion. The facts of Gomez Perez v. Potter were very interesting. An employee of the United States Post Office sued under the ADEA, the Anti-Age Discrimination Act, saying that she had been discriminated against by the postmaster. And she brought a retaliation claim, saying that because she had filed an administrative complaint, they had subjected her to retaliation. Now, under the private actor portion of the ADEA, which is the one that private companies have to hold to, there was a right for a retaliation claim. However, the ADEA then turns around, and when the federal portion of it was brought up, left that out. Now, Scalia didn't agree with this. Scalia said, as the government argued, that you don't get to pick and choose. That under the rules of interpretation, we don't assume a legislature where they explicitly discuss something or explicitly discuss the other half of something has then just brain farted on including it. And the federal portion not including the right to a private action for retaliation under the ADEA against a federal employee or against a federal employer was not part of the act that authorized the federal one. But Alito had no problem implicitly reading that protection in right there. The court, according to Scalia, who Alito accused Gorsuch of betraying the memory of today, said it was impermissible for Alito's opinion in Gomez Perez on that. That Alito could not have held that way in good faith. Alito argues sort of what I call the right to do what. If you're a fan of the Civil War arguments, you're going to be familiar with that. You know, it was about states' rights. Oh, the right to do what? Alito argues that the discrimination present is not based on sex. It must be tied to the LGBTQ plus status of the person. And I personally find that to be an intellectually disingenuous argument. It's clear that LGBTQIA plus status must be tied to sex at birth. Otherwise, we wouldn't have that status. If somebody is not male, then how are they gay? If somebody was not assigned male at birth, then how are they trans? If somebody was not assigned female at birth, how are they trans by being male? It essentially is almost an argument that LGBTQIA plus status is not an immutable aspect of a person, and that it is a choice-based one that somebody can choose to assume or not assume, regardless of their sex as assigned at birth. So it's a strange argument for Alito to be making. It really is. You would not expect that argument. I mean, it's... He even says that there not being there's a case called Price Waterhouse Cooper. And that one's an interesting case in that the claim there was a woman was passed over for promotion by not being stereotypically female enough, and they found Title VII as being in there. Alito comes back now and says, well, it doesn't matter. This is a different type of plaintiff because they are not being fired for not comporting to stereotypes by being LGBTQIA+. The logical fallacy in that argument is, of course they fucking are. It's the ultimate stereotypes. Boys act like boys. Girls act like girls. Boys marry girls. Girls marry boys. Anything outside of that is wrong. Those are the ultimate stereotypes. There is a moment where he goes into a very long discussion. I'm actually, hold on. Let me see if I can find this. Goes into a very long discussion of the definitions of sex that were in the dictionary in 1964. And says, well, of course it must mean these things. And that's no reference to sexual orientation or gender identity. But the party loses me is right here. Where he's talking about sex as being the sexual urge or instinct as it manifests itself in behavior and phenomena of sexual instincts and their manifestations. I'm just going to read this for you. Since both of these come after 3 prior definitions that refer to men and women, they are most naturally read to have the same association. And in any event, is it plausible that Title VII prohibits discrimination based on any sexual urge or instinct in its manifestations? The urge to rape? Whoa! Did a sitting Supreme Court justice just compare defining sex and discrimination based on sex as being linked to LGBTQIA+ status as being on the same level as someone arguing that sex could mean sexual urge and be used to defend rape as a protected status? What the fuck? By the way, his portion of this decision all about people fucking. Like, this man is inordinately concerned with who you're making out with and whose dick you're sucking. Alright? This 70-year-old man is just not okay. And it doesn't get better. It doesn't get better. You know why it doesn't get better? It doesn't get better because Alito's a fucking turf. Alito goes into a talk about discrimination and how it may affect transgender people being able to use things. And the very first thing he does is he goes to the wizarding world of Harry Potter and talks about vulnerable spaces and bathrooms. This is J.K. Rowling. When you throw open the doors of bathrooms and changing rooms to any man who believes or feels he's a woman, then you open the door to any and all men who wish to come inside. It is a matter of concern to many people who are reticent about disrobing or using toilet facilities in the presence of individuals whom they regard as members of the opposite sex. Under the court's decision, transgender persons will be able to argue they are entitled to use a bathroom or locker room that is reserved for persons of the sex with which they identify, and while the court does not define what is meant by transgender person, the term may apply to individuals who are gender fluid, that is, individuals whose gender identity is mixed or changes over time. Thus, a person who has not undertaken any physical transitioning may claim the right to use the bathroom or locker room assigned to the sex which they identify at that particular time. The court provides no clue why a transgender person's claim to such a bathroom or locker room access might not succeed. We immediately go, and I mean immediately go to the bathroom. Just immediately. It continues. And this is like the dog whistle greatest hits. Let's see. If we open the doors to transgender people being allowed to be employed without being fired, it's going to devastate women's sports, apparently, because there's all those trans athletes just waiting to take over the world of women's sports. Housing. Housing. College dorms will be infiltrated by the evil trans people. Employment by religious organizations, saying that it'll force religious organizations to hire and keep on LGBTQIA plus people against their religious precepts. Healthcare benefits. This is a fun one. That it may give you the right to claim you're being discriminated against under healthcare. Gee, that's not fucking relevant right now at all, is it? And like he explicitly, he's like, that's a bad thing if that person can insist that we give them treatment for their gender dysphoria. That's a bad thing. And all of our tax dollars. And then religious liberty issues. Freedom of speech. I shit you not. Alito says that if this stands, if LGBTQIA plus protections under Title VII stands, it will implicate other federal laws, and people may have to use preferred pronouns, and that would be a gross violation of their freedom of speech. So it's nice to know that Justice Alito and the guy who animates fucking furry dicks on Twitter is on the same page here. Not nice to know Alito and Jiggle Bones the fuckwit are on the same page. I almost slipped. I'm watching myself. Thank you very much, folks, for keeping me honest over the years. I mean, oh, this is a good one right here. The court's decision may also pressure employers to suppress any statements by employees expressing disapproval of same-sex relationships and sex assignment procedures. So, to be clear, Alito thinks it's a bad thing that workplaces may bar homophobic and transphobic statements around their employees. I just want to be clear on that. That Alito's argument, in part, is we can't let men into our bathrooms no matter what they call themselves. I'm speaking as Alito, not as me. And, workplaces may become more accepting, and that's a bad thing. Why would you write something like that? The very first reason that you may write something like that is dissents are often used in the future for jurists and people looking to overcome something called stare decisis, which is the respect that the Supreme Court has for prior opinions, to overturn those opinions, to find the grounds to do that. It also can provide a roadmap to legislators, such as our current Congress, who may want to amend the acts that these protections are based on. And if you doubt that, I would encourage you to go take a look at what some people are saying. The most common heard one I've had today is read Alito's dissent. I read Alito's dissent. I'm not impressed by it. But for the people who want to argue that the law should be changed to address this, because this is a federal law, so they can amend it. And then we restart the court battle. Is to give them the hook to hang their hat on. And to telegraph that if it's ever revisited, he has given them now an argument that they can point to. That is one thing. That there were a couple questions that came across today. The very first one is, what about at-will employment? And nothing's going to change for at-will employment. Right now, as it stands, a lot of people misunderstand at-will employment. And lawyers bear some of the blame for the misunderstanding of at-will employment. Because when people call us and they're like, I got fired, we're like, okay, well, we live in an at-will state. They can fire you for whatever reason they want. It's an oversimplification because very few of those cases actually would meet the exceptions on this. And really, we should change our statement to at-will employment means they can fire you for any non-discriminatory reason they want. Okay? At-will employment is simply, we don't have a contract, so I can fire you and you can quit at any time. But it does not give, the fact that an employer is in an at-will state does not give them carte blanche to ignore the law. All it says is you can fire them for any reason you want, but if you fire them for any of these reasons, it's still discriminatory. Okay? There's a lot of talk about, well, yeah, but they'll just say they fired me for this other reason, and that is, that's kind of how it works. You see, the way these work is when you bring one of these cases, the burden is on you to show a prima facie case of discrimination. It's always on you to do that. That's how it is. You have to show that a prima facie case has been met. Many times, the way you show that is, I am a member of the protected class. An adverse employment action was taken against me. It was taken against me because of this. Because of my membership in that protected class. That's your prima facie case right there. All right? The employer then comes in and says, no. That wasn't the reason we took that action. We took that action because of this. And then you come back and you say, no, that's the pretext. That's the reason they're giving. It's not the reason I was fired. All right? And how do you prove that it's a pretext? Way back at the beginning of this stream, I gave an example of Bob and Matthew. Bob is a gay man who is late to work one day, and Bob is fired. Matthew is a straight man who is late to work one day, and Matthew is not fired. Bob files a claim and says, I am a gay man. My employer fired me. All right? Membership in the protected class. All right? And an adverse employment action. I was fired because I was gay. Discriminatory act coming from that. There's your prima facie case. Now, this is in very boiled down terms. There's your prima facie case. The employer comes back and goes, no. We fired him because he was late. And Bob comes back and says, Matthew was late, and Matthew wasn't fired. The only difference is I'm gay, Matthew is not. Right? And that's where you go through and you build through. And it's never like, A, B, and they did the same thing. But you don't take actions against these people, or you don't fire these people when these things happen. Why was I fired? The only difference between me and them is I'm this and they're not. All right? That's how you overcome the pretext. And it's a building of evidence in that situation. It really is. But that is not putting you on a lesser standard than any other class. That is the same standard that would apply if somebody were to say, I was fired because of my race, or I was fired because of my religion. And that is really what I hate to say this, people aren't going to like it, that is what we strive to. Okay? We don't strive to a gay person, an LGBTQIA plus person can never be fired. We strive to, they cannot be fired simply for being LGBTQIA. And that if it is proven they are, like everyone else, that those laws impact, they are entitled to the full protection of the law, as it is written. At-will employment is not an immediate shield. I say this knowing people who make their livings suing employers who ostensibly dismiss and fire people or take adverse employment actions under at-will employment. And then you turn around and you say, no, that's not how it works, because we've got all this stuff here showing that you don't take these actions against everybody. You only took it against my guy. So at-will employment's not a bar. It's not a great standard, but it never will be. The fact is at-will employment is not a defense to a discriminatory act. And that now LGBTQIA plus people are on the same footing as every other protected class in doing that. I got a question earlier today about whether it would have a retroactive effect. No. In general, no. New laws cannot really be applied retroactively. So if you were fired 10 years ago by your employer because you were gay, I'm sorry. Not a lot you can do. This is not a retroactive thing. The employer is allowed to rely upon the law as written and interpreted at the time when they do that. So that would not cover that. Outside of that, I will, for the last 10 minutes, open it up to the chat, see if the chat has any questions. And then we're going to call it a night. Does constructive dismissal fall under the same but-for arguments? Yes. Adverse employment actions. Adverse employment actions. And remember, with the but-for analysis as espoused by the court and as set forth in Title VII, it does not have to be the cause of your dismissal. It just has to be a cause of your dismissal. The law is written to say because of sex, not primarily because of sex. It just has to be a but-for cause, not the but-for cause. And there's a question as to whether or not it actually has to be a but-for cause, because motivating factor from the 1991 amendments may apply. And if motivating factor applies, it doesn't even have to be a but-for cause. It just has to be a reason they did it, not the but-for cause. Is this likely to influence LGBTQIA plus Title IX law? More than likely. Once you have a case, and that's the thing about a lot of the civil rights amendments, is that definition you see. Okay, race. Let me pull it up real quick. Race, color, religion, sex, or national origin. Those protected classes are pretty consistent protected classes throughout all of the civil rights amendments and the rules promulgated based thereon. So, if it has that definition, you now have a Supreme Court case saying, in the context of one of the civil rights amendments, in the context of Title VII, sex means LGBTQIA+. Is it a guarantee that it will be consistently applied throughout them? No, it's not. It's certainly not. However, the road to argue that it shouldn't be and that it doesn't mean that just got a hell of a lot harder. Would this apply to someone who got glowing employee reviews up until the company picnic, where it was discovered by the company that they were LGBTQIA, and then after that their employee reviews start becoming mediocre or critical employee reviewed? More than likely, adverse employment action is the standard. That's where we get the other discrimination part. It's not just hiring and firing. It is other discriminatory practices. Other discriminatory practices generally applies to adverse employment actions. Okay? That means anything that negatively impacts your job. It can be consistently negative performance reviews changing right after that point with no commensurate change in it. It can be disciplinary procedures that other people are not being disciplined for after they discover it. It can be demotions. It can be cuts in hours. It can be changes in job duties. You have a job and they significantly reduce your duties after they find out you're gay. Those are all, and I'm not making these up, these are all things that other case law protecting people under the Americans with Disabilities Acts, the ADEA, and Title VII have said these are adverse employment actions. What happens if societal norms that are in place from sex at birth are deeply in place? E.g., a biologically assigned woman is fired from working at a pool for swimming without a shirt. A biologically assigned man would not be. Does a company policy like a dress code that is based on a long-standing social norm change whether this law applies? Good question. I would argue probably not. I would argue that there's going to be people saying that it's in place to keep them in compliance with the current law. And 9 times out of 10, those laws are going to be your indecent exposure laws, where they've been written to be like, the female boobie is bad and should not be seen. As it stands right now, what they are not saying, and that's a very good question, because what Gorsuch does not say is, hey, we're going to apply the laws that apply to whatever gender identity you have. What he is saying is we are determining that sex is an immutable trait, and that you cannot make an employment decision based solely on that. So that is actually a very good question. It's one that I am interested in seeing the courts follow on, especially as we move forward from here. However, if you're the type of person who is worried that your kid may see a trans man's nipple, I don't know what to tell you, man. I don't really worry about it. Like, I'd sit in my fucking couch without my shirt on all the damn time. Sorry, you're talking to a guy whose spouse breastfed all of her kids. The human nipple does not excite me or make me scream in terror. I'm a little weird about that. The Kavanaugh opinion's weird, Silence. The Kavanaugh opinion was basically the Alito opinion, but without all the weird necking and fucking stuff, and without the turf stuff, and kind of just really went with, I don't agree with it because I think that the legislature should be doing this, not us. Which was a little less than what I really expected out of it. I did not expect Kavanaugh or Alito to go full J.K. Rowling. I did expect it out of I Like Beer Frat Boy. So I'm a little surprised that basically his response was limited to, I disagree for the same reasons that guy said, but mainly the part where we really shouldn't read the intent in, and we should leave it to Congress to make that determination, which, by the way, is like the punt of SCOTUS, is like, yeah, we're not going to look at it. It's a touchy social issue, so we're just going to leave it up to Congress to change in 20 years. So that's kind of weird. So what did J.K. Rowling do exactly? A lot, man. A lot. So do we have anything else? I'm scrolling through the chat real quick before we call it a night on this. As a member of the United States Air Force, knowing more than a few LGBTQ folks, how would this affect the recent DOD change in trans folks at the military? Cannot say. And the reason I cannot say is the military code is different and has different protections than a lot of areas. I would hope that the Title VII protections will carry over, or at least make a good argument for carrying over. So that's going to be an interesting one on it. Let's see. Somebody sitting here says Sparf is making the joke. It's not SCOTUS's job to interpret the law, which is fine because Sparf. I know you're being sarcastic, Sparf. I am aware, but just for clarification, it is explicitly SCOTUS's job to interpret the law. That's what they fucking do. That's what they fucking do. The canon of donut holes. Gorsuch just referenced. The canon of donut holes is an old canon that says, the law is filled with holes. No law, if you write every law so that it covers every possible instance that it could apply to, you're going to end up with one law being a book this fucking big. So necessarily, there are donut holes in the law. There's loopholes. There's areas. Quack Quack, I did. Thank you very much. It's upstairs right now. But there are donut holes in the law. And the reference there is you can't hide an elephant in a donut hole. You can't use the fact that there may be an ambiguity or just a small little hole in the wall to shove through something massive because of that. So that is the reference to donut holes. That's what that was. Anything else before we do it? Because it's 8:30 and I'm going to fix me some hamburgers and watch me some TV. Depends on the micro elephants could probably get through. Just saying. How does this stuff work with hospitals asking for gender? In instances where certain medicines may react differently to male-female genes. I personally am not aware of any medicines that react massively differently. That would be a better question for your doctor. I certainly would not suggest you lie to a doctor if that is the thing that's going to be out there. But are you asking, can they ask that and then turn around and deny treatment based on that? Still a gray area because it's not a Title VII matter, really. We would have, somebody will probably bring the claim, more than likely, on that very recently, very, very soon. On that, especially in light of Trump's executive order. So let's see. I'm going to go through and take a look at this. What about prostate cancer? You won't find them in XY chromosome. How to do the recent DOD ban? Already said something about that that we don't know. So let's see. I think that's about it. Let me do a quick thing and read off the names of the Lawyers and Liquor Patreon supporters real quick, because they are the people who make this stuff possible, who fund the stuff like the renovations of the studio, who make me feel slightly better about sitting there at my job during the day reading through 172-page Supreme Court decisions and writing out fucking notes for this stuff. So special thanks out there to Wayland Roche, Beaton, Dozer, Trash Panda, Edley Willow Fox, Jack of all Corgs, Mark Beckwar, Mama T, Netherlinks, Uncle Kage, Dante PD, Lisa Lupe, Mark Phaedrus, Petroff Neutrino, Tezcat Magic Jag, Tyranth, Brophy, Buddy Goodboy, David Hunter, Ed B. Colley, Feck, Ghost Goat, Grace Jane Gollinger, Ian Delahorn, Mark Whipple, Michael Blocker, Pandemonium, Sean Rabbit, The Dragon Show, Ziggy, Andil Spitzen, Arrow, Quiver Shaft, Bryce Rogers IV, Kathy B. Lanham, Crypto Wolf, Douglas Shelby Jr., Drew the Finboy Fox, Erner, Gmo, Jenny Ann, Giza the White Mage, Jackal the Circle, Jeff Orr, Cataract, Loki Sorensen, Margaret Bumby, Michael Bryant, Nini Kiri, Nitro Fox, Odd Socks, and Quack Quack Honk. So thank you all so much for your support. I will be back tomorrow with a game stream as we continue playing the Outer Worlds. I will be back next Monday at 8 p.m. Eastern Time for another Legal Funhouse, hopefully this time with some less dramatic news going on. Until then, folks, thank you so much for joining me. I am Boozy. You are not. I will see you tomorrow night at 7 p.m. or next week at 8 p.m. You take care of yourself. And if you like the stuff we do here, I should always say this. If you like the stuff we do here, the games, the streams, the comedy shit, you can always feel free to support us by subscribing using Twitch Prime. Several of you have tonight. I'm sorry I didn't read your names off as I normally do. You can toss your bits all up in my face because we are Twitch affiliates. You can slide tip into the bank account. Just the tip, though. I don't want to get pregnant over at boozybadger.com or streamlabs.com/boozybadger. And become one of our Patreon supporters over at patreon.com/lawyersandliquor. And if you don't want to do any of that, that's perfectly fine. I don't do this shit to get rich. I do this because I like to talk to you. So, until tomorrow, I'm Boozy. You're not. You have a wonderful evening, and thank you for inviting me into your home. Good night.